Hi, my name is Aaron Lacey. I'm the chair of the higher education practice at Thompson Coburn LLP, and you are listening to Title IX Hearings, which is one of the sessions that's part of the Thompson Coburn Title IX training series. Thompson Coburn, if you don't know, we're a law firm located or headquartered in the Midwest with offices around the country, and we have a higher education practice, which means we have a group of attorneys who spend either most of or all of their time working with colleges and universities on a wide range of matters, including matters like Title IX, or Title IX compliance, I should say. The purpose of this training series is to assist institutions of higher education with complying with the new Title IX rule that becomes effective August 14th, 2020. If you listen to the first session, we talked a lot more about that rule and sort of how it came about. But one of the key features of the new rule is that you are, if you're an institution of higher ed, required to put into place a robust and complex and for many, we expect sort of a challenging new process for managing formal complaints of Title IX sexual harassment. And that process is going to involve a lot of people, advisors, investigators, adjudicators, appeal officers among them. And the new rule says you have to train those folks, and any training materials you use, you have to make available on your external website. So we've developed this series very much as foundational training for those individuals. It is our intent that institutions of higher education should feel free to use the training at their discretion, and also, to be very clear, to put it on your external websites if you want to. That's why we've done it, right? We'll just also add, if you want any sort of supplemental training or custom training on your policies or other matters, we are, of course, happy to do that as well. I mentioned earlier, so this is one of several sessions. More specifically, there are 6 that comprise the training series. And again, you are listening to hearings, which we think is going to be one of the better attended of these sessions because the hearings process is right at the core of this new rule, and it does involve some of the most complex and difficult concepts. This is the syllabus for today's session. So I'm going to start out just briefly talking about the formal complaint framework. As I've said in other sessions, I like to try to sort of level set and help people get their mind right, as they say, so you're ready for the rest of the information and have the context for it. When the rest of the session does start and you start marching through key concepts and these other matters, it will be these 2 gentlemen who do it. So we have 2 presenters for you today. The first is retired Judge Booker Shaw, who was a trial judge here in the state of Missouri, where I am located for many, many years, and actually then subsequently sat on the Missouri Court of Appeals. So Judge Shaw is quite literally a professional adjudicator, and he has a lot of great experience, and I know we'll have a lot to add to the conversation today. In addition, you've got back Scott Goldschmidt. Scott has been a part of all of the sessions here. He's a big part of our higher education practice, the former Deputy General Counsel at Catholic University in Washington, D.C. Scott has worked on a wide range of matters for institutions, including matters involving Title IX. Okay, so the formal complaint framework, just real quickly, again, to get you sort of set up before Scott starts to go into key concepts. Keep in mind, and you've seen this graphic in every presentation, the Title IX statute prohibits discrimination on the basis of sex in all programs and activities at institutions of higher education. So that could be discrimination on the basis of sex in any form. It could be discrimination in employment or recruiting or athletics. And if an institution gets a complaint along any of those lines, then they have to have a process in place for addressing and resolving that complaint. The new rule is focused more specifically on allegations or complaints of sexual harassment on campus, and includes a new definition that we're calling Title IX sexual harassment. And again, in the first session of the series, Scott and I talk about that definition of sexual harassment and how it relates to the new rule and the framework. But here, I just want you to keep in mind, the new rule is really focused on sexual harassment, not all forms of sex discrimination. And more specifically, it is focused on what an institution has to do if it gets a formal complaint of Title IX sexual harassment. And that is really where the machinery that is set out in the new rule for managing investigations and hearings and appeals, et cetera, all comes into play. It's when you have a formal complaint of Title IX sexual harassment. There is a definition of formal complaint in the new law. You see it here. The key components are that it has to be in writing from a Title IX coordinator or a complainant. More commonly, you would expect probably from the complainant. And it needs to allege sexual discrimination and request that the institution act, and in particular, carry out an investigation. If you get a formal complaint, that's when you have to start your new process. And you can see here, this slide lays out all the different elements of the formal complaint process that are required under the new law. And it's a lot. It's a lot to wrap the brain around. And in fact, most of our training series is really focused on walking through these various elements. You'll see there's only one highlighted for today. Again, it's hearings, but there's a lot to talk about in the context of hearings. So with all of that having been said, I will now turn it over to Mr. Goldschmidt. Scott, how are you today?
I'm doing very well, Aaron. Thank you. And it's sure a pleasure to be here and to hopefully help you walk through hearings, which, as Aaron mentioned, is a really important and complex arrangement of the new Title IX rule. So the first thing we want to do is ground a few key concepts. So I'll introduce these concepts here and then throw it over to Judge Shaw to really kind of explain what they mean and, based on his experience, how they can be administered. So the first one is treating complainants and respondents equitably. This is a concept that permeates the entire rule in all of our training modules, and just important to remind everyone here. One of the department's main focuses is that complainants and respondents need to be treated the same and fairly. That was a big impetus for the new rule, and that should really ground most actions that are taken by institutions. Next key concept is objectively evaluating all relevant evidence. And we'll get Judge Shaw's interpretation or his analysis of relevant evidence in a second. And that includes both inculpatory and exculpatory evidence defined. And also institutions need to provide that credibility determinations can't be made on a person's status as a complainant, respondent, or witness. So just because a person is making a complaint doesn't mean they're any more or less believable. Same with respondents. And last, we'll talk about the presumption that the respondent is not responsible for alleged conduct until a determination is made at the end of the grievance procedure. And that's something that needs to be explained up front in your processes and policies and in notices that you provide to respondents. So Judge Shaw, welcome and thank you for being with us. First question, just a really foundational concept that I think is going to take us through the entire presentation, and we'll have a section specifically on really intricate relevance questions later. But what is relevance? And when we talk about what relevant evidence, what do we mean by that?
Okay. Yes, thank you, Scott. So when we talk about relevance, what we're really talking about is whether or not this evidence is probative of a material fact. Does the evidence have a tendency to make the existence of a consequential or material fact more or less probable? And that would be relevant evidence. The problem can sometimes occur, though, Scott, when, well, we'll talk more about relevance as we proceed, but there can sometimes be some disagreements or discussion about what is relevant and what is not relevant. And so the decision maker will have to determine whether or not he or she wants to hear arguments or discussion about it. But I think as we go along, we'll see how this is going to be an important concept in the conduct of the hearing.
Absolutely. I definitely agree. So now that we kind of talked about what is relevance and what's relevant evidence, the key concept here was that decision makers need to objectively evaluate relevant evidence. And that sounds simple, but I assume it might not be. What does it mean to objectively evaluate relevant evidence?
And you hit the nail on the head there, Scott. It sounds very simple, but I can tell you, having heard countless trials and even on appeal, to keep an open mind until all of the evidence has been submitted, until you heard all sides of the event, can sometimes be difficult, and it is difficult for all of us. I would say that, jury research kind of delves into how people process information. And I think it's kind of hardwired into human beings to be effective, that is AFFECTIVE, decision makers. That is, we typically make our decisions, particularly when there is a conflict, we have a tendency to make our decisions relatively quickly based upon our past experiences, impulse, and emotion. And you can't do that. You have to be a cognitive decision maker. That is, you have to wait until you've heard everything. And there's always a tendency, particularly if the party who goes first, the complainant, for instance, goes first, and you hear everything that person has to say and all of the evidence they have presented, there's a tendency to make up your mind fairly quickly about what the outcome should be. And I've had it happen to me many, many times where I've heard one side and I thought, oh, well, I've got this one done. I know what happens here. And sure enough, you hear the other side and you go, oh, my goodness, no. So you have to just remind yourself that there are always at least two sides to a story, that you have to be very patient with yourself and with the parties. And I think we'll get back to this also as we proceed. It's not just being objective and keeping an open mind, but you want to be patient with the parties so they can see that you're keeping an open mind. Part of this whole process is for people to feel that they have been heard and listened to and that they've had a fair hearing. And so open-mindedness is something that I think one can communicate to the parties by being patient with them and listening to hear everything before you make a decision in a case.
Yeah, no, that is sure great points and great advice. I'll just add one piece here that's specific to the Title IX rule. The regulations explain that when decision makers receive a report from an investigator, they're not supposed to show any deference to any decisions or conclusions, and not that they should be made, that an investigator poses. The report is just to aid decision makers, but all evidence, as Judge Shaw said, needs to be reviewed and objectively evaluated based on their experience and their presentation of facts. And let me get to the second question on the slide. The regulations explain that decision makers need to objectively evaluate relevant evidence, including inculpatory and exculpatory evidence. So these are legal terms of art. Could you explain what those two terms mean?
Yeah, I mean, typically when you're talking about inculpatory evidence, that is evidence that's going to be presented by the complainant. That is, this is evidence that tends to show the respondent's responsibility. And exculpatory evidence is the other side of that coin. That is evidence that tends to show that the respondent is not responsible.
Thank you. And so one of the other key concepts we talked about is the presumption. Oh, I'm sorry, is credibility. So here, credibility determinations can't be made based on a person's status as complainant, respondent, or witness. So what are credibility determinations? How will they come up at a hearing, and why are they significant?
Well, credibility determinations are always going to come up in a hearing because it simply has to do with the believability of the witness, believability of the report, and the weight and significance to be given to any evidence that's submitted. And so I think throughout the course of a hearing, the adjudicator is going to have to weigh the evidence and make a determination based upon his or her own experience and common sense as to what evidence is believable and what evidence may be less believable. Oftentimes, in my experience, as jurors are instructed, you are to observe the manner of witnesses while testifying, whether the evidence that they're testifying to is something they directly witnessed, that is, they saw themselves, or something that they were told that happened, whether or not there's evidence that corroborates or supports the testimony of a witness. Is there any physical evidence, or is it strictly testimonial evidence? Is it circumstantial evidence? And circumstantial evidence and direct evidence, we'll get into that a little bit more later. And then sometimes the credible evidence is on both sides. So both sides are equally credible. But that's a determination that the adjudicator is going to have to make. One need not be intimidated about this, and you need not be a judge or jurist or lawyer to make credibility determinations. Jurors do it each and every day, all the time, all over the United States. So, basically, as an adult, you come into this process, and as an adjudicator would, based upon life's experiences. And I think that qualifies you to do so. And if it ultimately ends up being a he said, she said situation, as you mentioned, and the adjudicator finds that both sides are credible, then of course we look at what the standard of proof is. And of course, then the adjudicator will likely find that under those circumstances that the complaint has not been sufficiently proven. So this will happen, of course. But yeah, I think that an adjudicator will clearly be able to do this.
And the last key concept from that first slide that we talked about is the presumption of innocence, or the presumption of non-responsibility for the respondent. Judge Shaw, can you get into what that means and how the decision maker would have to understand this and apply it at the hearing?
Yeah, I think the presumption of innocence goes right along with keeping an open mind. It is because a complaint has been made that the adjudicator cannot assume either that it proves it or it disproves it. That the adjudicator simply has to keep an open mind until everything has been seen and heard. And that's simply what it means.
And that's I think that's right. And I think we'll get into this more when we talk about burdens of proof too, how it plays out. But that's a very helpful explanation here.
Mm-hmm.
So moving on to some other key concepts. So first, decision makers also have to make sure they don't have a conflict of interest or bias. And the regulations specify in two separate ways. So first, for or against complainants or respondents in general. So that could mean a decision maker that has a bias against respondents or athletes or something like that would just disqualify them completely. They cannot keep an open mind. And the second piece, you can't have a conflict of interest or bias against an individual complainant or respondent. So even if you could keep an open mind in general toward the status of the parties, presumably you might know the individual complainant, or you might know some history about them, or you might have interacted with them in a way where you can't keep an open mind. So both prongs are important, and decision makers need to ensure they don't have a conflict or bias in each. Second, as Judge Shaw alluded to, is the standard of evidence. And schools have a choice, absent state law requirements, of either the preponderance of the evidence standard or the clear and convincing evidence standard. And we'll explain what each mean and how you evaluate facts under both. And the last key concept for this slide is you can't require, allow, rely on, or otherwise use questions or evidence that constitute or seek disclosure of information protected under a legally recognized privilege. And we'll definitely get into that. And the caveat here is that presumption is there unless the person holding the privilege, the person actually waives that. So Judge Shaw, let's dig into the two standards. So the first one that schools can choose is the preponderance of the evidence standard. What does that mean?
So preponderance of the evidence is typically the standard used in courts and civil cases. And it's proof that a particular fact or event was more likely than not to have occurred. And so we often talk about preponderance of the evidence is 51% of the evidence on one side or the other. Or if, for instance, on the scales, a feather is enough to make one scale a little bit more than the other, that would be a preponderance of the evidence.
Perfect. And then I'd like to ask the same question, clear and convincing. And then if you wouldn't mind just expanding, if you were an adjudicator, how would, after explaining clear and convincing, how would each standard apply? How would you analyze facts under each? I'd be really curious to know your opinion on that.
Okay. So clear and convincing is a higher standard. That is, the adjudicator needs to be firmly convinced. It's not beyond a reasonable doubt, but it's proof that a particular fact was highly and substantially more likely to be true than untrue. So in the clear and convincing, it's a higher standard, but it's not proof beyond a reasonable doubt. The adjudicator needs to be firmly convinced. More likely than not is the lesser standard. I think in many instances, it's going to be a 50-50 situation. And in that instance, then the burden, the standard has not been met. And that often happens. We hear in trials, for instance, where you had a hung jury. And oftentimes the jurors will come back and say, well, we thought both sides were fairly believable, or we thought both sides were fairly unbelievable. So we determined that the burden of proof was not met here. In the legal realm, though, clear and convincing is a higher standard that is typically used under circumstances where the conduct is considered to be reprehensible or much more dangerous, or the penalties are much more severe. And so under legal standards that we use in courtrooms, the clear and convincing standard is only used in those rarer instances. And typically it's by a preponderance of the evidence.
Yeah, and that's a great distinction, and it's just important to emphasize that the absent of state law requirement that mandates each, schools really need to think through which of the two requirements kind of meets the mission and the kind of the goals of the institution, and then apply that standard for all formal complaints of sexual harassment. So let's move on and talk about live hearings. That's another requirement of the regulations for hearings. So under the standard, institutions are required to include a live hearing in their formal complaint process. Important to note, and this is especially important with smaller institutions that may not have a lot of personnel to kind of manage all these roles, and a lot of people wear different hats, but the adjudicator here cannot be the same person as the Title IX coordinator or the investigator. So just regardless of how many people you have on your staff, you have to make sure your adjudicator is not your coordinator or your investigator. So, absent a request from parties, live hearings can be conducted either with all parties physically present or with participants appearing virtually. And technology here, as we're doing in this training, is enabling everyone to see and hear each other, to kind of understand the demeanors and the actions, and to kind of see everyone in addition to hearing them. But at the request of either party, so either the complainant or respondent can make this request, and if they do, schools must provide for the live hearing to occur with parties in separate rooms. Again, with technologies enabling the adjudicators, the decision makers, to see and hear the parties, and the parties are able to similarly see and hear each other, or witnesses answering questions. Another application for schools is to create or an audio or audiovisual recording or transcript of any live hearing and make it available for the parties for inspection and review. So let's now talk about the rules for hearings. So Judge Shaw, in the past couple slides, we've discussed what the regulations require as a floor. But the regulations and preamble also explain that schools can institute certain rules and conduct that kind of fill in some of the gaps for how a hearing should commence. What are some of the rules that institutions can adopt, and should they?
Yeah. Well, Scott, I mean, I think it will be very important for schools to adopt rules of decorum and orderliness to avoid chaos. And these include the order of the proceedings, timing and length of breaks, prohibition on disturbing the hearings, and prohibition on badgering or arguing with witnesses. And I think, when I reflect on my experience, when I first started out as a judge, they start you kind of at the bottom of the totem pole. And I had a lot of these hearings without lawyers present, or very young or inexperienced lawyers. But oftentimes they were pro se, that is, people who were unrepresented by lawyers and knew nothing about court proceedings. And I heard small claims cases, and like you see on People's Court. And let me remind you, though, in real life, people don't behave as nicely as they do on People's Court. I had a lady hit a guy upside the head with a high heel shoe one time, and another guy grabbed a folding chair and hit a guy one time. And you may even want to consider having a security officer present, because these there is a potential for there to be high emotion in the room. And you don't want the process to completely break down because someone has been so affected one way or another that it's very difficult for them to control their emotions. So to have rules of decorum and order that the parties understand, that are explained, that are repeated, there is no reason for there to have this kind of unruliness, and nobody can complain of any ambush. They know what to expect, what the process is going to look like, and how they're going to proceed.
And yeah, great points. And just wanted to add that any rules you do adopt as an institution, just getting back to that first key concept of fairness and equitability, need to apply equally to both parties.
Yes.
So next, let's move on to talk about advisors, and we'll start with the requirements of the regulation with regard to advisors. So the first requirement is that schools must afford parties an equal opportunity to have an advisor during any aspect of the formal complaint process. So as Aaron previewed at the start of the presentation, formal complaint process is a specific term of art, and once that process is initiated, institutions have to afford parties an ability to have an advisor. Advisors may be an attorney. Advisors may not be an attorney. An advisor could be a friend, a family member, a classmate. But there's no prohibition, and there cannot be any prohibition on having an advisor also be a practicing attorney. So as schools can't restrict the choice of advisor or the advisor's presence. In certain situations, you may be able to restrict the activity of an advisor, which we'll talk about, but the fact that the advisor's presence is there can't be restricted. And schools may restrict participation in the proceedings as long as those restrictions apply. So this is the big topic of the new regulations, and I think we're going to spend a significant amount of time on that and really lean on Judge Shaw's expertise here. But first, let's get to cross-examination requirements of the rule. So adjudicators, decision makers, must permit each party's advisor to conduct cross-examination of any other party or any witnesses. The rules specify that the cross-examination must be at a live hearing and conducted orally, directly, and in real time. Never, the rules make very clear, can cross-examination be done by a party. The cross-examination always has to be done by the party's advisor. And if the party doesn't have an advisor, it's the obligation of the institution to provide one to the student free of charge to conduct that cross-examination. Now, when the institution provides an advisor, it can do it. It can choose an advisor of the institution's choice, but they still must provide an advisor or else that student would not have the ability to conduct cross-examination and wouldn't have the benefit of having someone advise them in the hearing. So the department here explains in the preamble why advisors are necessary. So cross-examination is a big touchstone of the regulations, and it's many times discussed how it's the best engine of determining the truth at a proceeding, and that's why the department's very keen on having this process here at these hearings. And the department makes very clear that this is an adversarial process. It doesn't have the same impetus or ability to get the truth and point across if someone's a neutral official conducting cross-examination. So the department's saying this is adversarial. We want an adversarial party conducting this cross-examination. And as we'll talk about later, that doesn't mean adversarial does not mean inappropriate or yelling or screaming or being rude. It just means that the interests of the party conducting the cross-examination are not the same as the interest of the person on the receiving end of it. So Judge Shaw, taking from your experience, I think you gave us a little taste of that with your high heel incident before. But let me start with a question about adversarial advisors. So if a complainant or respondent's advisor of choice refuses to comply with the school's rules of decorum that we explained earlier, so they're yelling at the other party, they're being rude, just things that are not helpful or conductive. Can the school require the party to use a different advisor?
Yes, and as you alluded to there, Scott, I think this is probably the area where there is the greatest danger of loss of decorum, because the phrase adversarial proceeding can sometimes be mistaken by some lawyers and others who are not lawyers to think that this is the chance to holler and shout and argue with a witness. What it means is that you're allowed to ask leading questions, that is, questions that suggest an answer or propose an answer. But in order for the adjudicator to maintain decorum, there must be some means by which an advisor who is completely out of control can be checked. Otherwise, the proceedings fall apart and you never get anything done and you can't reach any resolution that way. So I think this may be an important process and an opportunity for an adjudicator to simply say, we can't proceed with this advisor. And so,
let's touch about that a little more. So on the next slide, we're here talking about assuming we have attorneys, but really it could be anyone. It could be a classmate or a parent that just is overzealous, potentially in good faith of their potential advocacy on the part of their party. Just in general, how do decision makers, how do presiding officers maintain order?
well, I think what happens is typically the adjudicator at the very outset of the proceedings, when outlining what the order of proceedings is and what it will be and what is expected of the parties, it might be important to simply point this out. And judges often do this. Now, I say that there is a certain, I suppose, a culture in certain courtrooms and in legal settings where lawyers can be very, very aggressive. And so this could be a big problem. But I have more often seen it in my experience from non-lawyers who simply don't know that it's inappropriate to become belligerent and badgering. But then again, there are lawyers who think this is a way to impress people and this is an opportunity for them to put on some kind of show. So I think it's important at the outset for the adjudicator to explain to the parties that decorum will be maintained at all times. And should one of the advisors, for instance, be incapable of conducting themselves in a professional way and while adversarial, still with some degree of decorum and patience, then they may have to be replaced because the proceedings will have to be done in an orderly fashion.
Judge Shaw, I'm curious because I've known you for a little while now, and you are the kind of guy where you walk into a room, and I think people behave just because Judge Shaw has walked into the room.
Not so.
Not so. Was it always like that, or do you feel like over the years your ability to sort of maintain order in a courtroom there was a gravitas and a style of maintaining order that you sort of developed? And if the answer is yes, how do you think you changed? What are the things you learned over 20 or 30 years that you might impart to someone who's doing this for the first time?
Aaron, I think it's a combination of things, but mostly what I learned is to be patient and the recognition that as an adjudicator, my job was not only to be fair and impartial, but for the parties to feel that they've been treated fairly and impartially. And so that I tried to be very patient with them. But sometimes, decorum can be a difficult thing for people, particularly under very stressful circumstances where emotions are involved. And it's not like you have two businesses that have a conflict. If someone feels that they have been personally wronged or mistreated, then those emotions can be right on the surface. So I found that a number of things when we talked about this whole idea of decorum, you have to even think about the physical space that you're in and how it's set up and arranged such that it gives the appearance of a certain degree of formality in the proceedings. But I think the main thing that I've learned and what adjudicators need to practice is to simply being patient with people, explaining the rules clearly to people and following those rules and being patient with them.
Yeah, I think a lot of that certainly resonates, and I'll just make 3 points, and I completely agree with everything you said. But the first, I think you're right, that the recognition that this could be the worst day of both the complainant and the respondent's life, and something they've never kind of been involved in. So the recognition of that, the compassion of that, I think is extremely important. The second is, I think in the bench you have the trappings of a courtroom to help you out, and here you might just be in a conference room or a banquet hall or something like that. So doing something to kind of lend the degree of formality, I think could absolutely be there to help you. And last point, I mean, from a pure legal standpoint, the fact that someone feels heard and is able to feel like the process kind of worked for them, regardless of the outcome, I think very frankly could help lessen the appeals and litigation that could come, versus if someone just feels like the school didn't listen or railroaded them or something. So I think they're all great points, and I just wanted to.
Well, I can certainly tell you guys from experience, when I first started, they were in the process of rehabilitating the civil courts building downtown, and some of our courtrooms were in the process of being reconfigured. And for those, and they were shifting personnel around. So I did work in rooms from time to time that were not appropriately set up and where we did not have security. And I can tell you that there was a very clear difference in behavior in the parties in those kind of setups where we didn't have it in a formal setup and we did not have security.
Interesting. Very interesting. Very
Absolutely.
interesting.
And I'll just add very quickly, along with security, might also want to think about mental health resources and student affairs resources and all those things to help for these situations. But let's move on to a different part of cross-examination. So what happens, according to the regulations, if someone does not submit to cross-examination or refuses to submit? So if that's the case, the adjudicator cannot rely on any statement of that party or witness in reaching the determination of responsibility. There's a lot to unpack there, and we're going to go through it in a few slides coming up next. The one caveat to be aware of is the adjudicator can't draw an inference for the determination regarding responsibility based solely on a party or witness's absence. So just because a complainant or respondent does not show up, you can't take that fact into account as you're reaching your determination. So first question, Judge Shaw, very basically, for the purpose of these Title IX proceedings, what does it mean to submit to cross-examination?
Submit to cross-examination is simply that the person answered questions by the opposing party.
Absolutely. And as the Title IX regulations state, the only questions that you are able to answer are questions that are relevant. So I think that's exactly right. And just before we get into how the rules applied, does this exclusion of statement rule apply when a party or a witness does not answer questions by the adjudicator, by the decision maker?
No, because the adjudicator is not cross-examining the witness.
That's right. Simple as that.
Yeah.
Oh, you got to give Judge Shaw harder questions. I mean, he's not impressed.
We're getting there.
Not impressed with the simple stuff.
We're starting easy. This is next one's a tough one. So this is an interesting one, and this is going to be a very new concept for a lot of decision makers. But the rule on the exclusion of statements is predicated on what a statement is. So, Judge Shaw, what's a statement?
Well, as we see here, statement has ordinary meaning, but doesn't include evidence such as videos that do not constitute a person's intent to make factual assertions, or to the extent that such evidence does not contain a person's statement. So a statement would be a prior statement by that party. So police reports, SANE reports, medical reports, other documents and records may not be relied upon to the extent they contain statements of a party or witness who has not submitted to cross-examination.
Yeah, no, absolutely. And let me just follow up with that. How would an individual or a decision maker make a determination realistically if they can't rely on a person's statements, but there is video evidence or something that's not a statement? How would you, as a decision maker, mentally kind of be able to segregate statements from video evidence or things that you can consider?
Right, right. So if a witness does not submit to cross-examination, then you cannot consider their statements. But video evidence, that is, video evidence does not include a statement, is perfectly fine, and I assume that any other evidence regarding that witness would be fine. But simply that their statements would be excluded because they did not submit to cross-examination, whereby the opposing party would be able to test the credibility of those statements. So it just makes sense.
And this seems to me to be one of those situations where adjudicators are potentially being asked to unring the bell, right? Maybe you've heard those statements, you watched the video, and now you can't consider them. Following up on Scott's question, I'm just curious, Judge Shaw. It has always struck me that as an adjudicator, that notion that you have to set aside things that you may know, you have to unring bells that you have heard rung, it's got to be really hard in practice to do. I would think even for someone who's a seasoned adjudicator like yourself. Any tips on as to how folks can try to do that?
Well, I think we have to go back what I talked about before, Aaron, about keeping an open mind. And one keeps an open mind throughout the proceedings until everything has been seen and heard. And as the adjudicator is considering what, if anything, is being regarded as credible or not credible, then, the adjudicator has to be very conscious of the fact that certain items then cannot be considered whatsoever in the ultimate decision. So the adjudicator, it will not be an easy job. I can tell you from my own experience, this is why oftentimes judges much prefer to have jury trials, because the jury has, in many ways, the harder job, which the adjudicator will have, of determining credibility and the weight and value of the evidence. A judge, oftentimes, in a jury trial, you're just calling balls and strikes, and in many ways, that's an easier job. But for adjudicators to have to determine credibility and weight of the evidence is a difficult job, and so they have to constantly remind themselves to keep an open mind and what evidence am I considering and what evidence am I not allowed to consider in making my ultimate determination.
So next for you, Judge Shaw. This maybe we talked about this, but in these proceedings, can a decision maker ask questions of parties and witnesses?
Yes, and of course that makes sense. When I was a judge in bench trials, there are often things that I had some concerns about, or once the lawyers or advisors ask their question, if there is something that before the witness leaves or is concluded, then perhaps the adjudicator has a question that he or she wants to know the answer to that's material to the decision. Then the adjudicator it's perfectly appropriate for the adjudicator to ask that question and should ask the question.
That's right. And to the extent, I know we talked about earlier, relevance, one of the concepts the department lays out is that repetition of questions. So asking a question a second time, even if the first one was relevant, the second one is considered irrelevant. It was already asked. So to the extent that a decision maker asks a question and then it's repeated by attorneys on cross-examination or direct exam, whatever examination, that might be irrelevant and something for a decision maker and presiding officer to be aware of. So the next question for you, Judge Shaw, is about what happens when an advisor is not there. So a party has the choice of an advisor. That person does not choose an advisor, and the institution has to provide one. When is an advisor's cross-examination on behalf of that party satisfied?
Well, I think the purpose of this is to assure that the party is satisfied that their advisor has properly represented them. And so that if the party has a relevant question and they've asked their advisor to ask that question and the advisor refuses to do so, then the cross-examination is not satisfied. And so this should be brought to the adjudicator's attention. But I would have to think that this would be a rare circumstance where there is a relevant question. There may be some conflict perhaps between the advisor and the party. When the advisor says, well, it's not relevant that maybe this person cheated at marbles when they were in kindergarten. That's not going to be something important to the adjudicator. So, the further away you get from the conduct complained of, involving the parties involved in this particular complaint, then it may not be relevant.
Yeah, and just one thing to note on that is it's a fairly low standard that the preamble lays out for cross-examination to be satisfied. Does not require any advanced legal training to do that. So just as institutions are thinking about advisors to appoint, they should keep it.
Yeah.
Great. So moving along, so in the situation where a party doesn't appear, can a party's advisor still appear and conduct cross-examination even without their party?
Yes, and that makes sense. I can envision circumstances where a party may not appear, but yet still the testimony of the opponent can be tested by the advisor.
So Judge Shaw, last question here before I give you a little break. So let's think of a situation where a party, complainant, or respondent doesn't appear, but that person had recounted exactly what happened at issue to a friend or family member minutes after the incident took place. And that friend or family member is more than willing to come and provide testimony for exactly what they were told by the respondent or complainant. Is that allowed under the rules?
No, it's not allowed under the rules, Scott, and that's basically a rule of fairness. If the party did not submit to cross-examination about the validity of these statements and the truthfulness of these statements, then it simply would be unfair to have a friend or a family member come in and submit such statements for evidence.
Yeah, great point.
Thank you, Judge Shaw. Yeah. So let's take it now into relevance, and we introduced the concept at the beginning with a few key concepts, and we went over the basic definitions. But let's dive a little bit more into exactly what that means. So, with regard to cross-examination, as you mentioned earlier, only relevant cross-examination and other questions, including those challenged to credibility, may be asked of a party or witness. So, in terms of questions that can or cannot be answered, the one thing to remember is it relevant or is it not relevant? And a new interesting part of the rule, and one that really presiding officers need to understand in depth, and we'll get Judge Shaw's opinions on this, is that before a party or witness answers cross-examination or another question, the adjudicator, the presiding officer, must determine whether the question is relevant and explain any decision to exclude a question as not relevant. Still waiting on that slide. Not coming. All right. So first, one more thing. So questions and evidence about the complainant's sexual predisposition or prior sexual behavior. So here, this is for those familiar with legal concepts. This is a kind of rape shield protection. The rules say that those concepts are not relevant, with two exceptions. So the first exception is the questions or evidence about a complainant's sexual predisposition or prior sexual behavior are offered to prove that someone other than the respondent committed the alleged conduct. And second, such questions or evidence concern specific incidents of the complainant's prior sexual behavior with respect to the respondent and are offered to prove consent. So these are concepts that decision makers need to be aware of should they come up. In my experience, that wasn't too often, but they're very kind of nuanced. So, Judge Shaw, we mentioned one of the new things for a presiding officer is to make a relevance determination after every question. So first, can you explain what's required of a decision maker during that determination? And also, just based on your experience of kind of handling these in the courtroom, what's some advice or best practices you can give for adjudicators?
Well, this is a very interesting requirement, Scott, because in a courtroom, the judge is only required to give explanations when, first of all, there has to be an objection. And oftentimes the court simply says objection sustained and doesn't even say why. This is a very interesting requirement. I think for most jurists, the idea is when an explanation is given is that the shorter the explanation, the better, because it does not invite argument by the other side. When I looked at this whole issue, though, I thought it probably fit within the whole concept here of badgering a witness, or as you said, Scott, under rape shield laws that prevent the kind of character assassination based upon some allegation of provocative conduct or promiscuous conduct in general. But at any rate, I think that it should be enough for the adjudicator to simply either say that the evidence is relevant, and again, I would probably err on the side of letting evidence in, unless it is totally and completely off the wall irrelevant. Because I think, again, you want to give the parties the feeling that they have been fully heard. But if something is completely irrelevant, then I think it's the duty of the adjudicator to say that the evidence is not probative of any material fact, and leave it at that.
I think that's a perfect point, and we provided the citation to the preamble that lists exactly those words. This is what the department says. It could be a sufficient explanation. So exactly as Judge Shaw explained. So it's not probative of any material fact concerning the allegations. That's what the department said sufficient. So Judge Shaw and the department both think that's sufficient, and
Yeah,
adjudicators should sure consider it.
yeah, and I'll just add, if you're an adjudicator, a potential adjudicator, and you're watching this and that didn't make sense, rewind it and watch it again. Because the idea here is both the department and Judge Shaw are suggesting that a simple approach is not only allowed, but appropriate.
And in addition, and I mean, lengthy explanations could simply derail the entire process. You'd be going on and on, because at each cross-examination question, particularly, then the adjudicator must make a determination. So if there is a lengthy cross-examination, you can exponentially expand that cross-examination by giving these lengthy explanations. And there's no purpose for doing that.
Great point.
That's a great point. And that leads, I think, nicely into the next question. So Judge Shaw, I'd assume an advisor that just had their question deemed irrelevant by an adjudicator, presiding officer, would want to object. So the question here is, can a school adopt a rule applied equally for both parties, always, that gives or does not give advisors the right to kind of have those relevance discussions after a decision's been made?
Well, as you said, Scott, I mean, I think this leads directly from what I just said. I think it would be best to not invite arguments by the parties over these relevance determinations. And I can tell you from experience that when you invite these kinds of arguments and discussions, they can derail the entire process. And I was reminded the other day about a particular attorney who would never give up arguing, and almost to the point where I wanted to hold the lawyer in contempt of court for this. So I think, perhaps there are circumstances under which the adjudicator may want to exercise some discretion and ask why. Maybe the adjudicator is not, there are circumstances that I'm not anticipating here, but where the adjudicator feels, well, maybe I'd like to hear from you. Why do you believe this is relevant? But I think in most instances, it would be counterproductive to allow there to be argument and discussion about each of the adjudicator's determination. A waste of time. Yes.
That's right. I think that's a great point. And to that point, according to the preamble here, if a school makes the determination that they do not want these arguments, they're permitted to build that into their process. So just as in addition to the rules of decorum and the rules of the order of proceedings, just explain that we'll make it the adjudicator makes the determination, and that's the final word.
Yeah, I think that is the better choice, Scott. But I would pair that with the idea that the adjudicator should be fairly patient, and if there is some question in the adjudicator's mind about is this potentially relevant, then there should be the tendency to listen to it. And
perfect. Yeah, helpful caveats, absolutely.
Yeah.
So one question quickly on credibility, and I think it goes into managing the live hearing that we talked about. And we're getting a little bit ahead of ourselves because in the next section, we're going to talk about specific types of evidence, including character evidence and bad acts. But because we're talking about relevance in the live hearing too, Judge Shaw, can you give us a little preview of what character evidence and evidence of prior bad acts is, and then explain can relevant character evidence and relevant evidence on prior bad acts on cross-examination be excluded by a presiding officer?
Yeah, I mean, prior bad acts on cross-examination should not. There is no blanket rule excluding them, and typically in court, we discuss what's called other similar incidents, and so it is certainly relevant. The closer the prior bad act is to the allegation or the complaint under consideration, to the extent that it involves the same party or parties, then that's going to be relevant. But the further you move away from the act or conduct complained of here, the further away you move from the parties involved here, the more likely it's to be irrelevant. In court proceedings, there are often hearings held ahead of time to make a determination as to whether or not some bad conduct or so-called other similar conduct is relevant. And I think that's what the adjudicator has to consider. So there is no blanket rule excluding it. And to the extent that the conduct is similar to the conduct complained of, and particularly if it involves the same parties, then that's going to be relevant evidence.
I think that's a perfect point, and we provided you the preamble site really just to emphasize that the touchstone here, whenever you're thinking about types of evidence, is it relevant or is it not? And I'll ask Judge Shaw later how to weigh or advice on weighing different types of evidence. But for the purpose of this slide and this point, just want to reemphasize that if the evidence is relevant, then it comes in and needs to be considered. Mm-hmm. All right, so the burden of proof. So moving right along, so the burden of proof and the burden of gathering evidence by regulation, evidence sufficient to reach a determination is on an institution. So this means it's not up to the respondent to prove that they're to prove anything, not up for the complainant to prove anything. So the institution can't access, consider, disclose, or otherwise use a party's medical records without written consent. That's an important piece because a lot of these potential offenses, there are medical records involved, and the statute does talk about treatment records as such. Judge Shaw, I think I got a little ahead of myself in the next question, because this one's for you. But what does the burden of proof here, and I know it's different from your experience in the legal sense, but from a Title IX perspective, what does the burden of proof mean in terms of reaching a determination?
Well, the burden of proof, in my experience, and of course it will be for the adjudicators here, is this is the standard by which they determine whether or not the complaint has been proven. And it's again, as we discussed, was there a preponderance of the evidence? or is the adjudicator required to find that it was by clear and convincing evidence? It's simply the standard by which the adjudicator weighs the evidence and decides, has there been more evidence than the other side presented? Is it just one person's word against the other and these people are equally credible? Or under the circumstances where there is a clear and convincing evidence, is the adjudicator firmly convinced that the complaint is true? Then it's for the adjudicator to make that determination, and that's the standard that they have to use.
Yeah. Ultimately, it falls on the school. That's the idea of the Title IX obligations fall on the school, and the ultimate burden falls on the institution as well.
Yes.
Yeah, and important to treat the parties as such, that to not consider the complainant as having to prove his or her case, and not having the respondent to prove his or her innocence or non-response.
Right.
So here we previewed this a little bit. The types of evidence we're talking about. So I think just refresher from the last slide, when we talked about evidence, we mentioned all relevant evidence is to be included, but there's different types of evidence, and some is potentially more valuable than the other. So Judge Shaw, can you just give us a brief explanation of the different types of evidence that decision makers may see, and which evidence, how things should be weighed, and which is more valuable than others?
Of course. So you have direct evidence, circumstantial evidence, hearsay, character, and prior bad acts. So direct evidence, the example that lawyers often talk about in law school is direct evidence is a witness who is able to testify that they actually saw the thing being complained of. So it's the cookie jar example is the parent walks in and sees the kid eating cookies from the cookie jar. That's direct evidence. I saw the person doing the thing complained of. Circumstantial evidence, though, is not seeing the actual thing complained of, but seeing evidence that indicates the person did the thing complained of. So this is where the parent walks into the room, the kid has the empty cookie jar sitting in their lap, and there are cookie crumbs around the child's mouth and in their lap. That would be circumstantial evidence that the kid ate the cookies. But, circumstantial evidence can be more attenuated than that. It could be that there were cookie crumbs leading to the kid's room or whatever. What it is, though, is simply evidence that is not direct. That is, directly saw the person do the thing complained of, but circumstances that tend to indicate that the person did the thing complained of. Hearsay evidence is evidence offered by a party who neither saw the thing complained of or saw circumstances leading to the thing complained of, but heard someone say something regarding the event. That is, it's evidence offered by a third party, not an actual witness to the event, but offered for the truth of what they saw or what they heard, actually. Character evidence is evidence regarding a person's prior character for truthfulness and honesty. And prior bad acts have to do with what was this party's conduct with regard to relevant evidence that had to do with them doing something that would be similar to the event complained of, and typically involving the parties in the case where the complaint is being heard.
Perfect. And I think if I had that explanation when I was taking evidence, I might have learned it a little better.
I was thinking the same thing. That's the cookie example is so apt. I may use that with my kids. I have 3 middle schoolers, and I feel like we get a lot of circumstantial evidence around the house. Definitely some hearsay, definitely some character evidence, all of these things.
So let me follow up, though, on those great examples. So institutions, any of those pieces of evidence you just mentioned, need to be considered if they're relevant. But institutions can adopt rules that have different weight regarding different evidence. So what's your sense on a kind of a 30,000-foot view of how schools might want to weigh different types of evidence, direct versus circumstantial versus the others.
Well, there are a couple of ways to look at that, Scott. Typically, fact finders, whether they be jurors or jurists, are told that there are a variety of ways to weigh the evidence. And so we learned that in considering the weight and value of testimony of any witnesses, that the fact finder, and in this case the adjudicator, can take into consideration a number of things. The appearance, attitude, and behavior of the witness, the interest of the witness in the outcome of the case, the relation of the witness to any of the parties, and the inclination of the witness to speak truthfully or untruthfully, the probability or improbability of the witness's statements. But ultimately, the fact finder, and in this case would be the adjudicator, should give any evidence or testimony such weight and value as they believe the testimony is entitled to receive. And it all comes down to that. So I think that if institutions want to create rules, it should be a general rule to the effect that the adjudicator shall give any evidence or testimony of any witness such weight and value as they believe the evidence or testimony is entitled to receive. Because as we've discussed before, there are always going to be credibility determinations. And so whether evidence is direct, circumstantial, hearsay, character, or bad acts, it depends on what that evidence is and how credible it is. So, and only the adjudicator can make that determination.
Understood, and I think those are really important considerations to have. But based on your experience, is there a type of evidence that would be more useful for an adjudicator than other types of evidence?
For sure. And it's the kind of evidence that common sense tells you is going to be the most heavily weighted evidence, and that would be direct testimony of direct evidence by a third party who has no relation to any of the parties and is a completely objective observer. That kind of evidence, it's like an eyewitness to an event who knows neither of the parties and is not affiliated with any institution whatsoever. So that evidence obviously is going to be the most credible. And then probably, but see, it all depends, but just as a general proposition, if a witness or the evidence submitted is in relation to one of the parties or with relationship to one of the parties, either personally or professionally, and it is either hearsay, indirect, or circumstantial, that evidence is probably going to be less heavily weighted.
Understood. Yeah, and I think that's a good point for adjudicators to realize that there's a lot of factors that go into to how you weigh evidence, and it's really kind of it will be you, and that's why it's important that the adjudicators are the one that makes that decision as they objectively evaluate that relevant evidence.
Right.
Let's move on and talk about other pieces and access to evidence. So the rules explain, the regulations explain that throughout the hearing, institutions must review and afford both parties equal opportunity to review and inspect evidence that was obtained as part of the investigation and is directly related to the allegation. So here, one of the key terms here is directly related. So here we're not talking about relevant evidence. We're talking about evidence related to the allegation that's broader than potentially relevant evidence. And this includes evidence that the school doesn't intend to rely on, including irrelevant evidence, and inculpatory and exculpatory evidence. Timing. So this chart is important for institutions to keep in mind, because you will want to keep these deadlines in mind to the extent that there are deadlines, and build them into your process. So generally, the touchstone rule to keep in mind is that institutions have to provide access to evidence early enough so each party can meaningfully respond to the evidence prior to the conclusion of the investigation. So this makes sense if we're asking people to react to, respond to, be judged upon this evidence. You want to make sure people have access and understand it. Second, so prior to issuing the investigative report, the investigator would send all parties evidence subject to review and inspection and afford at least 10 days to submit a written response. This is a review from other presentations, but helpful to keep in mind. And again, 10 days prior to the hearing or other determination, the investigative report must be sent for the parties to review and provide response. And at or during any hearing, which is important for here and for the investigators, all evidence available to parties must be made available to parties, and equal opportunity to review that evidence, including for the purpose of cross-examination. And then that brings us to our last topic here, and another question for Judge Shaw. So I think way back in the beginning, we talked about legal privileges and how they may arise in the presentation, in the hearing, and with regard to questionings by adjudicators. Can you just explain what is a legal privilege, and how and why would it apply at a hearing?
A legal privilege means that the law recognizes that there was a communication made in confidence, and that confidence is honored by the law. And so the law recognizes that there are certain relationships in which, in order for those relationships to function as intended and as the law provides, then there must be some recognition that those communications are made and remain confidential. So here we have attorney-client, priest-penitent, doctor-patient, and spousal. And so in order for the attorney-client relationship to function as it should, the client should be permitted to make communication or enter into communications with their attorney with the understanding and assurance that those communications will remain confidential. Likewise, with the priest-penitent, statements made in confidentiality with the priest are to remain confidential. Likewise, with patient-doctor, likewise as between spouses. But I would point out to you that the statements need be made under circumstances indicating an intent that they be made confidentially. Now, that's typically not going to be a problem with attorney-client circumstances, but you may occasionally hear of or encounter circumstances where an individual made a statement and a priest happened to be present, or made a statement to a group of people and a spouse happened to be present. If this statement is made under circumstances not indicating an intent that the statement be kept confidential, then the privilege does not apply. Now, of course, so the privilege can be waived in that way if it's made publicly and in front of others where there was no indication that there was intent that it was done with an expectation of privacy. But under any circumstances, though, the client, the penitent, patient, or spouse can waive the privilege and say, I have no objection to that statement being publicly divulged. And so you have to examine each of the circumstances, but as a general proposition, these kind of confidential statements are inadmissible.
And I think those are great points. Let me ask you one last question. Put yourself in the shoes of an adjudicator, and potentially privileged information, doctor-patient information, is disclosed at the hearing, and the holder of the privilege does not want that information to be disclosed. But as an adjudicator, you've heard it. What would you do in that situation?
Well, I'm glad you raised that, because there are certain statements that are made to a doctor, that a patient may make to a doctor, that are not considered to be privileged statements. I mean, patients often make statements to their doctors that are offered for care and treatment and that are vital to care and treatment. And those statements the patient obviously knows are going to be shared with nurses and medical attendants and so forth and so on. And so those statements may not be privileged statements. And so let's assume for the purposes of this question, though, that it is determined to be a privileged statement and the adjudicator has heard it and then ultimately determines it's a privileged statement. The adjudicator must disregard that statement as if it never existed.
And with that, Aaron, I think I'll kick it over to you.
Thank you, Scott, and thank you both for taking the time to walk our viewers today through what is really a difficult concept. Just a reminder, we have some resources available to you. The Office of Civil Rights, first of all, it's actually their resource, has a blog. You can click on this picture of the web page if you have the actual slide deck, but otherwise you can probably just Google Office for Civil Rights blog, and I expect it'll pop right up. This is where they've said they're going to put their guidance and any further information on this rule as we move forward. So if you are a Title IX coordinator or someone who's trying to keep up with changes in the rule, you want to be sure to keep an eye on this particular website. We have a comparison document that should be available in the same place where you find the slides for these presentations, and it just shows you the changes the new rule made to the existing rule. And if you're like me or your counsel or Title IX coordinator are just curious, you may really appreciate this particular view. We have a higher ed webinar series. These are free webinars we do every year between August and May. We sort of track the academic year. They're all about topics in higher education, and they are free. They are CLE certified if you're an attorney and you listen in live. And if you can't listen in live, they are available after the fact on demand. You can go to our TCLE website, and all our webinars across our firm are posted there, and you just click on the box and they pop right up. We have a blog that talks specifically about higher education policy and regulation. We're talking a lot about the CARES Act right now, as you can see on the screen, but we also discuss matters involving Title IX from time to time. And finally, we periodically make available various publications that are really designed to be tools for the community, like our Bar Defense Rule Reporting Guide. If you'd like to sign up and get our alerts or information along those lines regarding when we've put out some new document or white paper or tool, just let me know, and we're happy to get you signed up. Finally, I will say on behalf of myself and Scott and Booker, we really appreciate you all tuning in. We hope if you've been listening all along and you've gone through the first several sessions that you found them useful. We hope you'll stick around because there are a couple more sessions here at the end that are also quite good. And I will say at the very end here, understanding once again that we're in the midst of the pandemic, more than anything, from Booker and from Scott and from myself, we hope that you will be safe and be well.